Hello everybody, thought I would just do a quick update here. I want to thank my friend very much. They have sent me some more documents and I'm going to put the link down below to our website for all these documents, and like I said, I'm putting them in the order starting with the oldest to the newest down to the bottom. It looks like there was some responses filed yesterday in the county court case with Pinkava and Scott, because it's two elders, and it looks like they might be in trouble up to their eyeballs. Yes, that's a technical term. I'm going to read hers first since she's the expert. A response was filed in each case by the Illinois State Attorneys yesterday. Essentially, both of the attached documents are the same. One is for Pinkov and the other one is for Scott. It is worth the read. Yes, it is. I agree, because I just got done reading them. In one part, it states the decision to not report resulted in 12 more years of progressively worsening sexual, physical, and psychological abuse upon a child who was 6 years old at the time. Now, if you didn't see the video I did yesterday, I had read that Pinkava, and Scott, they're claiming that they had called the legal department at Watchtower headquarters in New York and were given bad advice. They were told not to report it. It was clergy privilege, and they're claiming they got bad legal advice. A couple of things about that. Now think about this. When I was reading that, Pinkava is a retired school teacher. A school teacher. He knows better. He knows he has to report this. So to claim he got bad advice, I ain't buying it for a minute. I think it's a CYA, because he knows. He knows. Now, looks like the court isn't buying it either. Well, even here in the document dated March 10th, defendant seeks to admit self-serving hearsay statements. In support of this request, the defendant alleges that he received direction from an attorney in New York as to the child abuse reporting requirements with respect to an instance of a child abuse reported to him on July 27, 2006. Defendant further alleges that this direction, whether correct or incorrect, is what he relied upon in ultimately not reporting to authorities the information he was told. And like I said, he knew because he was a teacher. Statements made by defendant to the police or other witnesses in this case are inadmissible, as they are hearsay statements which do not fall under any of the exceptions to the bar against hearsay statements. And then they give some legal precedents. While the people would normally object to such testimony based on the Illinois rules of evidence and case law prohibiting self-serving hearsay statements, we have no objection here, as the decision to not report resulted in 12 more years of progressively worsening sexual, physical, and psychological abuse upon a child who was 6 years old at the time. The state welcomes any and all testimony from any and all persons involved in the decision making to not report sexual abuse of the child X reported to the defendant on July 27, 2006. So it looks like they are going to have the Watchtower lawyer testifying in the Zoom testimony on March 17th. Defendant is raising the defense of the following advice of counsel. I'm on page 2 now, point number 2. In his most recent attempt to explain why he failed to report child abuse disclosed to him on July 27, 2006. Specifically, the defendant states that he relied on this advice in deciding to not report the incident to the authorities as required under mandated reporting laws of Illinois. Defendant is a member of the clergy. See, now years ago, even in an Awake magazine, they said that the elders, that Watchtower does not have a clergy laity class. And now they're claiming they are clergy. Well, of course, when it protects their backside. And therefore, mandated reporter pursuant to 325 ILCS 5-4. The statute reads in pertinent part, the following persons are required to immediately report to the department when they have reasonable cause to believe that a child known to them in their professional or official capacities may be an abused child or a neglected child. Number 9, any member of the clergy. So he was required, so he cannot claim this. And to allow a child to suffer for 12 more years, that is disgusting. I'd like to see him hung up by their you-know-what. There's no excuse for this. No excuse at all. I digress. Going on with her information here. Like I said, she has a legal background. I do not. So I appreciate, your comments on, these legal documents very much. Illinois mandated reporting statutes provide that a first offense for non-reporting is a Class A misdemeanor. And it looked like that's what the original citation to these two guys were last year. Originally is just, like I said, a non-traffic citation, Class A misdemeanor. But not reporting such a crime for a second or subsequent offense, whether it is about the same person or about a different person altogether, is a Class 4 felony. And if the non-reporting person acted as part of a plan to prevent the discovery of an abused or neglected child by the authorities for the purpose of protecting or insulating any person or entity from arrest or prosecution, the person is guilty of a Class 4 felony for a second or subsequent offense. And she even says, I think these elders are up to their eyeballs in trouble. I agree. That's why the thumbnail. So, like I said, I am going to have the documents added to our website on this, and we'll keep you, informed and updated as we're getting this information. But they cannot use this as an excuse, and I hope the court sees this for what it is, because we know exactly what it is. This right here, she's got it in bold. Part of a plan to prevent the discovery of an abused or neglected child. We know Watchtower, that's what they have been doing since the 50s. It's part of their plan to keep this hidden. So it doesn't bring reproach on Jehovah's name. Yeah. So thank you so much, everybody, for watching. And we appreciate your love and support and emails. You have a wonderful day. Bye.